The grandeur of the Supreme Court chamber seemed to shrink into a tense, silent vortex as Justice Amy Coney Barrett leaned forward, her sharp gaze locked on Pam Bondi standing at the podium below. What had begun as an ordinary constitutional hearing now teetered on the brink of becoming a legal duel that would echo far beyond those marble walls. Barrett, known for her composed and meticulous questioning, broke that mold in a heartbeat. "Miss Bondi," she said, her voice firm enough to slice through the hush that had gripped the room. "Your constitutional argument collides head-on with settled precedent, in no less than 3 major rulings. Perhaps a refresher on Harrington versus Davis would have served you well before presenting such theories here." Her dismissive tone caused a ripple among the other justices, eyebrows lifted, notes paused mid-scribble. For a moment, the tension flickered towards embarrassment, but only for a moment. Pam Bondi, Florida's first female attorney general turned lead counsel for a coalition of states, stood motionless as Barrett's pointed rebuke echoed off the chamber's polished stone. For court watchers, this was the moment everyone had speculated about. Would Bondi falter under the highest judicial scrutiny, confirming the whispers that she was unprepared for this level of constitutional warfare? But what came next shattered every expectation. Beneath her composed posture, Bondi harbored a depth of legal insight that even Barrett hadn't anticipated. Taking a breath, Bondi's reply was calm, almost conversational, yet behind it lay the weight of months of meticulous preparation. "Thank you for raising that, Justice Barrett. I am indeed familiar with Harrington, and if the court allows, I'd like to clarify why it actually reinforces, rather than contradicts, our position." A flicker of interest crossed Barrett's face, polite skepticism mixed with a hint of challenge. "Proceed," she said curtly. Bondi did more than proceed. She launched. Without glancing at her notes, she recited Harrington's controlling language, then peeled back layers most observers hadn't even known existed. She connected it seamlessly to a specific reading of the Commerce Clause, quoting Chief Justice Reynolds's limitations word for word. Then, in a pivot that turned the room electric, she linked that holding to a lesser-known concurrence by Justice Kavanaugh, sketching a 3-part test that laid the groundwork for her entire case. For a moment, it seemed as if the entire courtroom leaned in. Barrett, now sitting a fraction straighter, narrowed her eyes, not with contempt this time, but with sharpened interest. Here, in the heart of America's highest court, a routine challenge had exploded into a live, masterclass-level debate between 2 formidable legal minds. As Bondi pressed on, the shift in the chamber was undeniable. What had started as a stern reprimand was morphing into an exchange of sharp legal ideas, the kind of constitutional back-and-forth that law students dream of witnessing. Bondi's voice stayed level, her delivery methodical yet riveting. Without once glancing down, she pivoted seamlessly from Harrington to an even more obscure precedent, Westmoreland versus United States. She reminded the justices how that decision had underlined limits on federal overreach, even when legitimate national interests were acknowledged. Justice Sotomayor, who until then had remained an observer, leaned in, her tone a mix of curiosity and challenge. "Counsel, Westmoreland is a little-known 10th Circuit ruling, hardly Supreme Court precedent. Are you saying it binds us here?" Bondi didn't flinch. "No, Justice Sotomayor. But this court cited Westmoreland with approval in footnote 23 of Montgomery versus Louisiana. That footnote clarifies the scope of federal authority over traditional state prerogatives. It's directly relevant to how Harrington should be read today." This precision startled more than one justice. They flipped through thick binders as if confirming Bondi's references in real time. Seizing the momentum, Bondi turned to the second front Barrett had opened, Article 3 jurisdiction. She calmly invited the justices to revisit an overlooked dissent by Justice Scalia in Williamson County. She laid out how that dissent, though once in the minority, was later resurrected and enshrined in Nick versus Township of Scott, a move that effectively rewrote parts of the prior majority's logic. Barrett interrupted, but this time her tone carried genuine interest. "Are you suggesting, Miss Bondi, that Nick's property rights holding applies here in the federalism context too?" Bondi didn't miss a beat. "Yes, Your Honor, but not through a mere analogy. I'm arguing that the reasoning has been extended by a series of lower court rulings, which collectively expand its constitutional reach to exactly the type of overreach we're confronting today. A flicker of acknowledgement crossed Barrett's face. She turned slightly, as if to signal her fellow justices that Bondi's argument deserved more than casual dismissal. What was supposed to be a demonstration of Bondi's shortcomings had flipped into a lesson in deep constitutional interpretation. The courtroom had stopped being just an arena for questioning, it had become a crucible for shaping legal doctrine in real time. By now, the Supreme Court chamber had shifted from a battleground into an elite seminar in constitutional law. Every word Bondi spoke drew the justices deeper into her framework, a framework that had begun as a defensive rebuttal and now threatened to redefine the federal-state balance. Justice Alito, always quick to test the outer edges of an argument, leaned forward. "Miss Bondi, your interpretation runs dangerously close to undermining our ruling in Denison. How do you reconcile that?" Bondi did not rush. She paused, absorbing the weight of the question. Then delivered her reply with the calm precision of someone who had anticipated every trap. "Justice Alito, I deeply respect the Denison framework. But our facts don't erode it, they reveal its natural boundary." Even Justice Gorsuch acknowledged in his majority opinion that unique cases may require more nuanced balancing when state discretion is functionally eliminated by federal reach. She then quoted Gorsuch word for word, her voice unwavering. Murmurs spread through the rows of clerks and legal correspondents. Barrett watched, head tilted, studying Bondi not as an opponent anymore, but as an intellectual equal. When the Chief Justice signaled that Bondi's allotted time was running out, the atmosphere changed yet again. Instead of panicking or rushing, Bondi distilled her remaining points with the clarity of a professor summarizing a masterclass. Just as she prepared to yield, Barrett, her demeanor transformed from skeptical to genuinely engaged, interjected with a final, intricate hypothetical. It tangled federal taxation, state regulatory loopholes, and conflicting sovereign interests, a scenario dense enough to stump seasoned constitutional scholars. The room held its collective breath. Bondi smiled faintly, the faintest trace of steel beneath her poise. "That is an excellent hypothetical, Justice Barrett. It spotlights precisely the tension our case raises." Then, in what would be replayed in law schools for years, Bondi unpacked the hypothetical step by step. She identified 3 constitutional principles at stake, cited relevant precedents for each, and, to everyone's surprise, wove in Barrett's own writings from her time on the Seventh Circuit as support. A hush fell over the chamber. Barrett's eyes softened, her posture less rigid. She knew exactly what had just happened. She had tried to push Bondi into a corner. Instead, Bondi had used Barrett's own judicial reasoning to strengthen her case. This was no longer a courtroom lecture. This was the forging of new constitutional thinking, live, under the watchful gaze of America's highest bench. When the Chief Justice finally announced that Bondi's time had officially expired, an unexpected ripple spread through the chamber. Justice Barrett, who had begun the hearing almost dismissive, leaned forward and, with measured authority, requested that Bondi be granted additional time to finish her framework. It was an extraordinary gesture, one that signaled not only respect but a tacit admission. Bondi's analysis had become indispensable to the court's deliberations. Returning to her podium, Bondi wrapped her final points with the same crystalline clarity that had stunned even her critics. She proposed a 3-part standard to reconcile state sovereignty with legitimate federal oversight, a standard so robust that legal commentators would soon nickname it the Bondi test. As she stepped back, the chamber erupted into a quiet buzz, clerks whispering, journalists feverishly updating notes. In that moment, it was clear to everyone that the once questioned advocate had just written herself into constitutional history. Outside the courtroom, the impact was immediate. Legal blogs dissected every line of the exchange within hours. Headlines read, "Barrett meets her match, Bondi redefines federalism debate." Cable news shows debated the broader implications for state power and the subtle shift in the court's ideological balance. For Bondi, the moment became transformative. Law firms that once overlooked her now clamored for her insight. Prestigious law schools sent invitations for guest lectures. Even more astonishing, when the court delivered its final decision 3 months later, it sided with the coalition of states, adopting large portions of Bondi's framework. The majority opinion cited her oral argument explicitly, a rare tribute to an advocate's direct influence. Justice Barrett penned a concurring opinion that openly engaged with Bondi's theory and even acknowledged the persuasive power of her reading of prior precedents, a nod so rare it immediately became a case study in humility and evolving judicial thought. Months later, at a Federalist Society event, Bondi and Barrett shared a stage for the first time since that fateful hearing. Barrett spoke first, her words echoing the transformation of that day. The greatest moments for constitutional progress often arrive when our assumptions are tested by an advocate who sees the law through a different lens. Bondi, dignified and poised, added, "Our system only thrives when ideas, not egos, win the day." That day, the ideas won. In legal circles, the phrase, "pulling a Bondi," became shorthand for an underestimated advocate outthinking the bench. For Barrett, the exchange fortified her reputation for intellectual honesty, proof that true judicial temperament includes the humility to be persuaded. And for every young lawyer and student watching that day, one lesson burned brighter than any headline. In the Supreme Court, brilliance knows no title, only the strength of your ideas.